Your doctor says you need a procedure. Your insurance company says no. And somewhere inside that denial letter is a phrase you've probably seen before. Does not meet medical necessity criteria. That's it. No explanation. No breakdown. Just a wall. Here's what they don't tell you. The exact criteria your insurer used to deny you. The clinical document. The page-by-page checklist that determined your care. They are legally required to hand it over the moment you ask. And almost nobody asks, because almost nobody knows. This video is for educational purposes only, and does not constitute legal or medical advice. Here's how this plays out for most people. You get the denial. You call the number on the letter. Someone reads you a script. You maybe file a first-level appeal, which is reviewed by the same insurance company that denied you the first time, and then you give up. That's exactly what they're counting on. Prior authorization denials are not rare. They're a business model. A survey by the American Medical Association found that 73% of physicians reported that prior authorization delays led to patients abandoning needed treatment. 73%. Think about that. And the cost to you isn't just your health. It's real money. Out-of-pocket costs for procedures that could have been covered can run into the tens of thousands of dollars. When someone pays $42,000 out of pocket for a surgery their insurer denied, and they never appeal, that's not a mistake. That's the intended outcome. Here's the thing most people don't understand. Insurance companies don't write their own medical necessity standards from scratch. They license them from third-party companies. The two biggest are Interqual, owned by Change Healthcare, and MCG Health, formerly Milliman Care Guidelines. These are proprietary clinical decision tools, algorithms, essentially, that your insurer feeds your case into, and the output determines whether you get care. You've never seen these documents. Your doctor may have seen a summary, but the full criteria, the exact thresholds your case was measured against, you are legally entitled to that. And here's the angle nobody talks about. The criteria themselves can be wrong for your situation. That's your leverage. Point 1. The law that forces them to hand it over. This is grounded in federal regulation. The relevant rule lives under the Employee Retirement Income Security Act, known as ERISA, and its implementing regulations under the Department of Labor, specifically 29 Code of Federal Regulations Section 2560.503. If your plan is employer-sponsored, this applies to you. Under ERISA claims procedure rules, when a plan denies a claim, it must provide, upon request and free of charge, all documents, records, and other information relevant to the claimant's claim for benefits. And the regulation defines relevant to explicitly include any guideline, protocol, or similar criterion that was relied upon in making the adverse benefit determination. That last phrase is the key. Relied upon in making the adverse benefit determination. That is the Interqual chapter. That is the MCG criteria set. That is the exact clinical benchmark your case was measured against. They have to give it to you. Now, if you're on a fully insured individual plan, not through an employer, you fall under state insurance law instead. But as of 2021, the No Surprises Act and its implementing rules extended similar disclosure requirements through the Consolidated Appropriations Act. And most states have their own independent surprise billing and appeals laws that mirror or exceed the federal floor. So how do you actually request it? You send a written request, certified mail, to the insurer's appeals or grievance department. You say, verbatim, pursuant to 29 CFR 2560.503, I am requesting all documents, records, guidelines, protocols, and clinical criteria relied upon in making the adverse benefit determination dated, and then you put the date of your denial. You include the denial reference number. You keep a copy. They have 30 days to respond, and in urgent care situations, that drops to 72 hours. If they don't respond, that's a procedural violation, and it actually strengthens your appeal. Has your insurer ever stonewalled you on paperwork like this? Drop it in the comments. I read every one. Your experience might help someone else in this exact situation. Point 2. What to do with the criteria once you have it. This is where most people stop. They get the document, it's 50 pages of clinical language, and they put it down. That's the wrong move, because this document is now your weapon. Here's the counterintuitive part. The criteria document doesn't just show you what standard you were measured against. It shows you exactly where your case either fit or didn't fit, and more importantly, where the insurance company's reviewer may have made an error in applying it. Insurance company reviewers, the ones who deny your claim, are not always specialists in your condition. Under ERISA, you have the right to know what kind of reviewer evaluated your case. You can request that information in the same letter. Was it a board-certified physician? Was it a nurse? Was it someone with no specialty training in your specific diagnosis? Here's a real mechanism you can use. When you have the criteria document, you take it to your treating physician, your specialist, the person who actually knows your case. You ask them to write a letter, a detailed clinical letter, that maps your specific clinical findings directly to the criteria language in that document, line by line. If the criteria says documented failure of 2 prior conservative treatments, your doctor cites the exact dates, the exact treatments, the exact documented outcomes. You're not arguing with the insurance company. You're showing them that their own criteria, applied correctly to your facts, requires approval. This strategy works because it removes the insurer's wiggle room. They can't hide behind vague medical necessity language when you're holding their own checklist and checking off every box. If you want to understand the full appeals process, including how to escalate past the insurer to an independent external review, and why external review overturn rates can be surprisingly high, that's exactly what we break down on this channel every week. Subscribe, and you won't miss the follow-up on external reviews. Point 3. The independent external review, and why it changes everything. Most people think the appeals process ends with the insurance company. You appeal, they review their own denial, they uphold it, and that's it. That is not it. Under the Affordable Care Act, for most health plans, after you've exhausted the insurer's internal appeals, you have the right to an independent external review. This goes to an organization that has zero financial relationship with your insurer. An independent review organization, an IRO, makes the call. And under federal law, their decision is binding on the insurance company. Here's the number that should stop you cold. A report from the Kaiser Family Foundation found that consumers who pursued external review won, meaning the insurer's denial was overturned, at rates ranging from 39 to 59%, depending on the state and plan type. Nearly half of the people who pushed to external review got their coverage. That number exists because most denials that survive internal appeal are still wrong. The internal process is designed to exhaust you, not to find the right answer. The deadline to request external review is typically 4 months from the date of the insurer's final internal denial. That clock starts the day the letter arrives. Miss it, and you lose the right. This is not a soft deadline. Here's the connection most people miss. The criteria document you requested in point 1 is not just useful for your internal appeal. When you submit your case to the IRO, you send everything: the denial letter, your doctor's clinical letter mapping to the criteria, and the criteria document itself. The external reviewer sees that your insurer applied their own guidelines incorrectly, or that the guidelines they used were outdated, or that your case clearly met the threshold their reviewer ignored. That full package is what wins external reviews. One more thing on external review. If your plan is a self-funded employer plan under ERISA, meaning large employers who pay claims directly rather than through an insurance carrier, the ACA external review protections apply through a parallel federal process. You're not left out. You request the external review through the Department of Labor. The mechanism is different. The protection is the same. Now, for those of you dealing with Medicare Advantage denials, the process runs through a separate track under the Centers for Medicare and Medicaid Services. You can request a qualified independent contractor review, a QIC review, which is Medicare's version of the IRO. The timeline is tighter, but the criteria disclosure right still exists under Medicare regulations, specifically under 42 CFR 422.562. Know your plan type. The process differs. The right doesn't. Here's our take, and we'll be direct about it. The prior authorization system, as it currently operates, is not a clinical gatekeeping tool. It's a financial friction machine. It's designed to create enough administrative weight that the majority of patients abandon legitimate claims before they ever reach the point where the insurer has to pay. The criteria document request is the first move that breaks that friction. It signals to the insurer that you're not a passive claimant, and passive claimants are the only kind of claimant the system is profitable against. Have you been through a prior authorization denial? Did you appeal? Or did the process just wear you down? Tell me what happened. Drop it below. And I read every comment. You now have the 3 moves. Request the criteria document by law. Use it to build a clinical mapping letter with your doctor. And if the internal appeal fails, take it to external review with the full package. The system counts on you not knowing any of this. Now you do. Next up, the independent external review process, start to finish, including the exact language that gets IRO reviewers to overturn insurance denials. That one's already on the channel.